Excellent, thank you. My presentation today is on prenatal testing, disability equality, and the limits of the law. So I'm going to start the conference by talking especially about the law on abortion on the grounds of disability, which is an important focus at the conference, on the Crowter case, on reasons why people have problems with the law, think it's discriminatory, different challenges that have been made to try to change the law. And I'm also going to speak about the limits of the law, why I think that we should also think about other issues that go beyond the law itself. I should say before I start that it's difficult to define disability and disabled, and there are people who have conditions that can be detected in prenatal testing who wouldn't consider that they're disabled, and it can be difficult to attach these kinds of labels. So I am going to refer to disability and disabled in my talk because I refer to the law and it makes sense by reference to the law, but it's not to say that we should use different language in other circumstances. Right, so here's the starting point of the law on abortion on the grounds of disability, and which will be a focal point for a number of presentations today as well. The position in English law is that abortion is a serious criminal offense unless you can have a lawful abortion under one of the grounds in the Abortion Act. And the main provisions are here in section 1.1 and A, B, C, and D. So the vast majority of abortions take place under section 1.1a, which is if there's a risk to the pregnant woman's health, physical or mental health, and there's a time limit for that ground of 24 weeks gestation. And abortions can also take place up until birth with no time limit if there's a risk to the woman's life or a significant risk of harm to her, or here we get to section 1.1d, if there's a significant risk that the child will be seriously handicapped, so the disability ground. So that disability ground is available up until birth. It's important to note that the way that the law is worded is not rights-based. A woman can't automatically have access to an abortion if one of these grounds is met. So two registered medical practitioners have to form an opinion in good faith that one of these grounds is met. So we might ask, what's the justification for the disability ground? Is there a moral justification for the law? So why is there an explicit ground in the law, and why is the ground available up until birth? Imagine there was in the law an additional ground that said it was possible to have an abortion if the fetus was female up until birth. It's hard to imagine that, but if there was, I'm sure people would be quite outraged and say it expresses a very negative view about girls and women. And I don't think anyone would say it only expresses a view about female fetuses. So there are a number of different reasons that have been put forward in the academic literature to perhaps explain this ground. Usually reasons based on the child's interests are dismissed on the basis that at least the vast majority of children would have a life worth living. It would be worth it for them to be born. And the main argument in the academic literature in terms of what could justify this ground is based on the parents' interests. And it's sometimes thought that the parents have an interest in avoiding what are often perceived to be the additional burdens that arise with raising disabled children. So I wrote about this some years ago, and I had a number of different responses to that argument. One of the main points I made is that I think that's a very narrow understanding of the parents' interests. Parents' interests are much, much broader than just avoiding these perceived burdens. And I won't go into all my reasons now, but in any event, I think that it's not logical to say that that's a full justification, because if we were concerned mostly about burdens, then we might ask why it's not possible to have an abortion for other reasons that are based on burdens. Why only that particular type of perceived burden? And also, if it was based on burdens, you'd expect that the decision maybe should be mostly or only coming from the parents' own views and not through the opinion of doctors. So many people think Section 11D is discriminatory, it can't be morally justified, and there have been a number of attempts to change the law. Here's a picture of Lord Shinkwin. He introduced 2 bills in the House of Lords that attempted to change the law on abortion. Both those bills are no longer making any progress, but there are a few different suggestions. One was to remove Section 11D, another was to keep it in the law, but to apply a 24-week time limit to that ground as well, and also to provide parents with more information about raising disabled children. A major criticism of some of these suggestions is that it might limit women's reproductive autonomy, their choices, and it might cause harms to women. It's important to understand, though, that it would be possible to change the law and, for example, remove an explicit reference to disability in a way that would be possible to do it in a way that restricted access to abortion, but also in a way that would liberalize access to abortion as well, or that would not really make much change. So if we're concerned about the wording of the law, there are a number of different ways that the law could be changed, and that may or may not affect access to abortion. The practice would be a different question. How many abortions on the grounds of disability take place would be a different matter. So I want to say a bit more about information, because it's a very important issue. So a very common critique is that in the process of prenatal testing, the information provided about the conditions tested for is very negative. It's very negative about disability. And so it wouldn't necessarily allow pregnant women or parents to make a fully informed choice. And so that was one of the suggestions that would have addressed this in the bill, was that information could come more from disabled people themselves. So we might ask, who is well placed to provide information? Are medical professionals best placed to do this? Are disabled people and their families better placed to do this? And what kind of information should we provide? What kind of information do parents want to have? What information is helpful for them to have? And is it possible for them to have all the information that they need in a short period of time during pregnancy? The people providing the information, the sources of information, are not necessarily neutral. Doctors might be thinking about avoiding legal liability. If they don't disclose risks of disability, they can be sued potentially. The health service, the state might be concerned with limiting costs as well. And in the past, there were studies with explicit cost-benefit analysis. So there have been some recent attempts to provide perhaps better or more balanced information, which can be seen as an improvement over entirely negative information. So here are some excerpts, for example, from a leaflet called Screening Tests for You and Your Baby. And you see that here there's, I think we'll hear maybe more about this later in the conference, but you can see there's some information which seems to be positive and some information which seems to be negative about Down syndrome. And I think the attempt is to provide a step forward with more balanced information. But it's quite difficult, isn't it, to think about how information can be balanced and how to talk about the value of people's lives in a balanced way. So there was a video that came out in 2014 called Dear Future Mom, and it was circulated very widely on the internet. I think more than 8 million people saw it on YouTube. It's still available there. And there was a woman who wrote to an organization and said, I've just had a diagnosis that my child will have Down syndrome, and I'm worried, and I don't know what kind of life my child will have. And the video is a response to her from people with Down syndrome who explain, who provide her with an answer. And so they start off saying things like, he'll be able to hug you, he'll be able to run towards you, he'll be able to speak and tell you he loves you. And towards the end, they say, your child can be happy and you'll be happy too. So it's had a lot of views. It was famously, it was banned in France from appearing on television. It was considered to be maybe offensive for women who've made different choices. Some people said the video was too positive. But it shows that the information can be quite different, and also maybe it can be helpful to have information circulating in society before, that can be seen by people before they have children, before women get pregnant as well. So Chris Capozzi is one of our speakers at the conference. We'll hear from him this afternoon. He wrote a book called Choosing Down Syndrome. And in it, he explains that looking at the narratives of parents who talk about their experience of having a child with Down syndrome, parents often talk about being transformed by their child, by having new values that they develop from raising a child with Down syndrome. And he says that people often say they had values centered on achievement and advantage, individuality, independence, and then they come to have values about what's more important in life, like compassion and care and unconditional love. This was a change that was brought about by the birth of the child and caring for the child. What kind of information do parents receive in society generally as well, which might inform choices that are made? So, here are some examples from 2013 parliamentary inquiry, where parents of disabled children said they were told statements such as, your child is a detriment to the rest of society, your child is a drain on resources, it's not fair for a sibling, it's too bad you weren't able to take care of it before birth, and your child will not have a good quality of life. Funding, I think, is also a very important issue that people consider. A lot of parents say they don't feel they have adequate funding. Childhood disability is often a trigger event for poverty, and many women raising a disabled child work less. Because of that, 16% of mothers with disabled children work, compared to 61% of all mothers. But in terms of funding, prenatal testing is offered to all pregnant women. So that's fully funded. And 99% of abortions are funded by the NHS. I think it's helpful when thinking about the choices that are made to not focus too much only on the individual decisions that pregnant women and parents make, but also to think about the role of society and the state in the context and in shaping decisions. I presented some negative information that some parents receive. Women are often blamed for deciding to have their child, and they're often blamed for having an abortion. So they're often blamed no matter what choice they make. So the choice comes in the context of inadequate information and funding and support, with discrimination and pressure, And as I said, it's difficult to have all the information you need if it seems that people change their views after they have their child, discover values they wouldn't have understood previously, and if there's information that you might need to have maybe a long time before pregnancy if you want to fully understand the issues involved. I think if you think more about the role of the state and the law and funding, it's worth thinking that there are eugenics considerations as well. Okay, so I come now to the Crowter case. So this was another attempt to challenge the law based on human rights. Heidi Crowter and two other claimants brought this case, and they lost in the High Court, but the matter is ongoing. There might potentially be an appeal. At the start of the case, at the start of the judgment, one of the things the court said was it acknowledged that there's quite a sensitive debate on these issues, on ethical issues, and it highlighted that the court can't enter into those controversies. It must decide the case only in accordance with the law. Right, so the claim was based on arguments that Section 11D is incompatible with the following rights in the European Convention on Human Rights: the right to life, prohibition of torture, respect to private life, and prohibition of discrimination. I won't go through all the detailed arguments that were made, but I'd like to highlight a few issues that arose and that came out from the judgment in this case. So one thing that was said was that Section 11D does not perpetuate and reinforce cultural stereotypes to the detriment of people with disabilities. That was said in a fairly brief section of the judgment on this issue. And I know Heidi Crowter, after the judgment came out, said that she does feel discriminated against by the law. And Professor Seor, who we'll also hear from during this conference, presented evidence that was referred to in the case about how Section 11D can create stigma, can lead to stigma against disabled people. Something else that was said in the judgment was that a very difficult balance has to be struck by Parliament between the interests of the fetus and the rights of women. And in their view, it is plain that Parliament had the legitimate aim of protecting the rights of women. So this is often the way that the debate is framed. It's often framed as being between the woman and her unborn child, the rights of the woman and the fetus. Now, as I said earlier, the law itself, Section 1 of the Abortion Act, is not, it makes no explicit reference to rights. It's not explicitly framed in terms of rights. And for a lawful abortion to take place, two medical practitioners have to authorize it. Also, I think we could ask further questions about what the legitimate aim of the law is. Is it to protect the rights of women? Or is it possible that the aim of the law might also be to prevent the birth of disabled children? I think we have to ask that question as well. Something else that was said in the judgment was, we do not know what would happen in a counterfactual world in which some women have been compelled by the fear of the criminal law to give birth to children who will not be loved or wanted. I think we can ask here, is it true that no one in society would love or want a disabled child? And if that's true, what does that say about the kind of society that we have? Doesn't society have a responsibility to look after disabled children? And if parents are supposed to love and want their child, maybe society also has a responsibility to help parents feel that way about their child. In terms of the fear of the criminal law, I think I've already spoken about this. Abortion is not permitted in any circumstance. The question really is, why single out disability? So if you think more broadly about the role of rights and society's responsibilities, I think that we expect more and more of the law to provide society's moral conscience, to provide the moral conscience that we want to have. And I don't think that the law is entirely well equipped to do this entirely. The language of rights frames women and children against each other. It frames disabled people and others in society against each other. Does not emphasize responsibilities, including those of society. And I don't think it can provide all the values that we need. So Hans Reinders has written that when people no longer want to get involved in the lives of dependent people, it signifies a cultural rather than a political, or you might say a legal problem as well. The reason is that no public policy can resolve the problem unless it can tap cultural resources that motivate citizens to value the commitment it requires. And he says it takes a particular kind of people to care for disabled persons and to enable them to flourish. So we might say that we need particular kinds of people in a particular kind of society. But recently on social media, through Mencap, Northern Ireland, there was a video of this woman who was explaining her story. She said that when she was pregnant and it was suspected that her child had Down syndrome, she was frequently told that she had options and tests, but she wanted to give birth to her child. And when her child was born, she said it was soul-destroying, that everything was so negative. No one said congratulations, even though she was happy. And she said, all you want to do is scream it from the rooftops, I've had my baby, and you're so excited, but no one is excited for you. So I think that the law can do many things, and it should, but I'm not sure it can make people excited. Right, so here are my conclusions, I think, where I've come to this far. So the law is discriminatory, and there are good reasons to change it, although there are different ways that this could be done. I think it's unhelpful and misleading to frame the debate as being between the pregnant woman and her child, especially if society is not living up to its responsibilities towards disabled children and their parents, while encouraging prenatal testing and abortion on the grounds of disability in a way that could constitute a form of eugenics. But I think there are also limits to what the law can achieve. So just to be clear, I do think that we should think about the law, and I think it's very important, and I think that thinking about rights is also very important. And I'm really glad that we have the Crowter case that has drawn our attention to many important legal and other issues. But perhaps I prefer this as a question. What do we need to do if we want to have an ethical society that is capable of welcoming disabled children? Perhaps we need to think about the law and think about a number of other issues as well. So I will stop there, but I think that throughout the rest of the conference, you will hear many different views and suggestions. as to what an ethical society might do, some more suggestions about the law, and also many broader ideas about an ethical society.